Your insurance company just denied your PIP claim. You're hurt. The medical bills are piling up, and you may already be getting collection notices for unpaid medical bills. And the company you've been paying premiums to for years is telling you no. What do you do now? Can you actually sue your own insurance company? In Massachusetts, the answer may be yes. And here's what you need to know. I'm attorney John Sheehan, a Massachusetts workers' compensation and personal injury attorney. Today, I want to talk about your rights when your PIP insurance company denies your claim after a car accident. Before we get started, please note, this video is for general information only and is not legal advice for your particular situation. Massachusetts is a no-fault state for car accidents. That means after a crash, you file a PIP claim with your own insurance company for your medical expenses and lost wages. And at the same time, you may file a bodily injury claim with the at-fault driver's insurer for your pain and suffering and other damages. The no-fault system means PIP pays regardless of who caused the accident. It doesn't matter if the other driver was at fault. It doesn't matter if you were. PIP coverage is required by Massachusetts under Chapter 90, Section 34M of the General Laws. It pays for your medical expenses and a portion of your lost wages, up to $8,000, and it's supposed to be your first line of financial protection. In my experience, insurance companies deny PIP claims for a number of reasons. They may say you didn't submit your claim on time, and the law does require you to file it as soon as possible and no later than 2 years from the date of accident. They may say you didn't provide enough documentation of your injuries or your medical treatment. They may dispute whether your treatment was reasonable and necessary. Or their independent medical exam physician, what's called an IME doctor, may have issued a report with a cutoff date, essentially declaring that reasonable and related treatment ended on a specific date. That's known as an IME cutoff, and insurance companies use it to stop paying for your medical care. I've seen cases where insurers deny or delay PIP claims without good reason. And when that happens, Massachusetts law gives you real remedies. Here's where the law is very specific. Under Chapter 90, Section 34M, PIP benefits are due and payable once you provide your insurer with reasonable proof, meaning your medical bills and the related medical records documenting your injury, your need for treatment, and that the charges are fair and reasonable. That's what triggers the payment obligation. You produce the documentation, they pay. When an insurer refuses or cuts off your PIP benefits after an IME cutoff, and those benefits remain unpaid for more than 30 days, you have the right to sue your insurance company and contract. Not just complain, to sue. And here's something else the statute says that most people don't know. If you win, the court shall award you costs and reasonable attorney's fees on top of the benefits owed. The legislature built that in specifically to level the playing field against insurance companies. Now, a breach of contract claim is powerful, but Massachusetts gives injured claimants another tool that can raise the stakes significantly. Chapter 93A and Chapter 176D of the General Laws. Chapter 176D requires insurance companies to handle claims fairly. It prohibits unfair settlement practices, things like unreasonably denying a claim, unreasonably delaying payment, or failing to conduct a proper investigation. When an insurer violates Chapter 176D, that's not just a breach of contract. That's bad faith. Under Chapter 93A, if you can show your insurer acted in bad faith, that it willfully and knowingly engaged in unfair practices, you may be entitled to double or triple damages on top of what you're owed. That's a very different conversation than just recovering unpaid PIP benefits. But there's a process. Before you can file a Chapter 93A lawsuit against your insurer, you have to send a demand letter outlining specifically how the insurer violated Chapter 176D. That letter gives the insurer 30 days to respond and make a reasonable settlement offer. If they don't, or if the offer is inadequate, you can proceed to court seeking enhanced damages. This is exactly the kind of leverage an experienced attorney can use on your behalf. Look, insurance companies have lawyers. They have adjusters. They have people whose full-time job it is to find reasons not to pay your claim. When your PIP claim is denied, you're not just fighting a billing dispute. You may be fighting a company with deep pockets that is betting you won't push back. An attorney can review your denial, evaluate whether the insurer had a legitimate basis, and determine whether you have a breach of contract claim, a Chapter 93A bad faith claim, or both. And because the PIP statute allows for attorney's fees if you win, you shouldn't let the cost of hiring a lawyer stop you from enforcing your rights. There are also strict deadlines that apply to your claim in any lawsuit. Time is of the essence. If you wait too long, you may lose your right to collect. I've been fighting on the side of injured workers and car accident victims and their families throughout Massachusetts since 1993, and I'm ready to fight for you. If you have questions and want to find out how I can help, please call my office for a free, no-obligation consultation. And if Spanish is easier for you, hablamos Espanol.